Good evening, Captain Matt Edwards, retired here with the next installment of the Observation Post Weekly Report for the 6th of October, 2022. As usual, I think I tend to go too long, so I'm going to try to keep it to at least, less than a half hour. Okay, point number 129 on my list of draft ideas. Is the Service Income Support Insurance Plan, Policy 901-102, unsustainable? Now, that's not my question. That was in a report put out, by the Mercer Corporation when the government hired Mercer to evaluate the program. And then they said they weren't sure if the program was sustainable. Now, the problem is many problems there. One of the main problems is that they seem, at least in my expert opinion, they've been trying to distance themselves from the Manulife Service Income Support Insurance Plan for a long time. So it seems like, to me at least, that in 2006 the government brought in the earnings loss benefit, and it seemed like they were going to swap that for what, the SISIP plan. But the SISIP plan didn't want to go away. There's the Department of National Defense, they have the Service Income Support Insurance Plan. And then the Veterans Affairs Canada people, they have the earnings loss benefit, which became the income replacement benefit. So as much as Veterans Affairs wanted to get rid of SISIP, the people that were running the program wanted to keep their golden goose laying eggs. So here they are, still operating. But as far back as 2015, the government put out the Canada Gazette in 2015, and they said that they were going to end SISIP as of 2025. Now that's only 3 years away. But they were going to give people time to get ported over from one program to the other program. Anyway, as far as I'm concerned, it's all a load of horse shit. Because it's not unsustainable, it's just that they don't like to have high costs. And there are more and more people getting medical release, and SISIP is the first provider of income replacement on medical release. So therefore, the cost for the Department of National Defense goes up. Point number 130. Past consideration and the condition of benefits agreement. Now, last week I spoke a bit about consideration. Now, consideration is the amount of money that is paid from one party to the other party in a contract. Now, in the SISIP program, for example, the contract isn't, the payments that are being made out of the contract isn't consideration. The premium being paid by the person wanting the insurance is the consideration being paid to the government of Canada. I got to get used to saying now His Majesty the King instead of Her Majesty the Queen. So the soldier, the Canadian Forces member, has money taken off of their pay. Now that pay, the premium, the contribution, that is the consideration just in case something happens. It's the risk of being disabled that is being covered. So what I was putting in there was the past consideration, because they put in the condition of benefits agreement in section 3.2.1 that the Service Income Support Insurance Plan would be the first provider of income replacement, as I previously stated. Now I'm a little bit off track here because my dog is up there barking like crazy at something. But the thing is that past consideration is no consideration. Even if the payment that was being made out of the Service Income Support Insurance Plan was consideration, which it's not, it is simply the insurance that someone bought. So if you get the insurance, you're getting what you paid for. Now they, of course, try to reduce it as much as possible with clawbacks, or try not to give it to you in the first place. For example, when I tried to get my long-term disability, they said to me that you had to be hurt in service. So I said to them, excuse me, but how the fuck am I going to prove that? If I have, if I'm out on an exercise and I'm in the back of a truck and the truck flips over and then I lose a leg or an arm or something, then you can visibly see, that I'm disabled. But if I have an invisible disability, how the fuck am I going to prove that to you, you bastards? Now, so they eventually accepted that if I had seen a doctor on a day that I was on duty, that they would accept it. But they shouldn't have to do such an ad hoc measure. They shouldn't have that rule there in the first place. Because why should a person who's injured on duty, why should a person who's injured off duty or got sick off duty be treated any different than a reservist versus a regular force person? Because that is the reason that they have the different clauses. The clause that says I had to be hurt on duty is section 43, I think, of the contract. And basically, it's a way for them to weasel out of ever having to pay. Now, point number 131. Privacy and overcollection of personal information. The spirit and intent of the Privacy Act is not to catch liars, for example. My VAC 928E form. Now, I'll give a brief overview of the Privacy Act. Privacy Act came into effect in 1982. It's a quasi-constitutional law which limits the amount of information that the government can collect when it needs information to run a program. So it is not meant to protect the government. Like, for example, there was a soldier who committed suicide, and when the parents asked for the personal effects of the soldier, they said they couldn't release it due to the Privacy Act. Now, that is abusing the Privacy Act, because the Privacy Act is supposed to protect people from the government and not the government from the people. You see? So they shouldn't collect too much information from us if they already have it, for example. So when I mentioned the 928E form, that's a Veterans Affairs Canada form, and back, I'll give a brief recap again for those that already know the story. Excuse me for repeating myself. But back in 2012, I was released medically on the 19th of January 2012. I never got SISIP right away. It took over a year to get it, until March or April of 2013. So after 7 or 8 or 9 months of not getting nowhere with Manulife, I went to Veterans Affairs Canada, and I said, what can you do for me? These bastards are not doing nothing for me. So they put me in the rehabilitation program. Now, I was fighting with VAC, or the Department of National Defense Manulife, about the injury on duty, and they were not giving me SISIP. One of my main arguments to Manulife and the Department of National Defense was that, the President, Pierre LeMay, said on this date that if you get medical release, you will automatically get your long-term disability. And I was medical released, so why am I not getting my long-term disability? And they said, well, that didn't cover reservists. Of course, the President at that time did not differentiate between a regular force and a reservist. So when I was approved for the rehabilitation, a couple of days after I got approved, I got this letter in the mail. And it said, here's this 928E form, and you're a rotten bastard who is lying to us because you said you were medical release, and you also said that you weren't getting SISIP. And we know that everybody who gets medical release gets SISIP. Well, I nearly hit the roof, because here was the same argument that I was making to Veterans Affairs Canada. Veterans Affairs Canada was saying they agreed with me, and they didn't agree with the Department of National Defense. But they ought to have known about the clause in the contract, because they had the very same clause in the law under the Veterans Wellbeing Act. They have very similar provisions. So, and they also have a program arrangement in place between the Department of National Defense, SISIP Financial Services, and the Department of Veterans Affairs. So, one of the key problems I have, because I do a lot of thinking about this stuff, one of the key problems I have is that Veterans Affairs Canada wanted me to give them a blanket consent form, a VAC 928. I'm hoping to, Keith. They wanted me to give them a blanket consent form to allow them to get whatever information they wanted, but at the same time, they already had a form, the Department of National Defense did, in the SISIP 6E release application process. So they had a blanket consent form that could have allowed them to talk to each other, and as I explained back when I was trying to call them out 2 or 3 or 4 years ago, I said, listen, boys, all you had to do if you wanted to know if I was lying to you, all you had to do was call the Department of National Defense. Now, once you contact the Department of National Defense and you said, can you look up Captain Retired Matt Edwards' file, they would get the file, they would look in the file to see if there was a consent form there. And if there's a consent form there, which there was, they could talk to you all they fucking wanted to. But VAC sent their consent form, set me up, drove me fucking crazy at the time, because it was exactly what I was saying. And there's two departments, the left hand don't talk to the right hand, and they're both arguing about who should have the money and the power and the influence and all that stuff. So each one, for example, wants to be the one who certifies service injury. Now, most people would think that the Department of Veterans Affairs is the agency that does the certification of injury on duty. But there are at least 3 instances of where the Department of National Defense has to certify if a person was injured on duty. The first one is in Section 41.3A3 of the policy, or 43.1A or something of the policy, which states that, is the reservist injured on duty, because they had to certify that, or you don't get your insurance. The second one is for a return of contributions. Now, I don't believe that for a moment, but there was a Access to Information Act request I saw where former Minister of National Defense Peter MacKay, they were talking about refunding the amount of the contributions, the premiums a person had when they were hurt in duty. Okay? So, if you're hurt in duty, they say on paper you're supposed to get your premiums back. Now, that's not how insurance works, but they said it. And the third one escapes my mind at the moment. But, it's for reserve force compensation. So the reservist again. So there's this system, sort of like workers' compensation, that the Department of National Defense must certify if a person was injured on duty in order to go through a thing under CBI, Compensation and Benefits Instruction 210.72. I got a head for numbers, okay? So the CBIs, which are a replacement for the Queen's Regulations and Orders, I guess now they'll have to replace them and say the King's Regulation and Orders. So that's the third instance that I can tell you that the Department of National Defense actually has to certify injury on duty. But in 2016, the Canadian Forces Ombudsman put out a report, and they were talking about we should be the ones who certify injury on duty. And in a way, it's very true, but they already do it. But I agree with them, because the Department of National Defense is the one who certifies you to be medically released. So I'll go through that briefly. I guess most people probably know it. But you go through what used to be called an Army Review of Medical Employment Limitations, or, well, that might be the newer name, but the old name was called a Career Review Board Medical. So if you go in for your annual medical, every 5 years under 40, every 2 years over 40, if you go in for your medical and your medical category exceeds what you need to be for your trade, then they can medically release you. But they first do a process where the doctor's report is sent to a board of 3 other doctors, I understand, and they review that with A, the person will be kept without any limitations, B, they can be kept on with limitations, or C, they have to be medically released. So this is the process of the Army. The Canadian Forces Health Services, CFHS, they have all the information on hand. All the person's medical documents, everything is with the military, not with the Department of Veterans Affairs. Now, but the thing is that because they're fighting about who certifies it, they leave the disabled soldier and who will become a disabled veteran in the lurch, because they would have, each department being the one who takes center stage, and they make it about them instead of about us. That's what I keep saying as an expert opinion, and people might think that I'm crazy because I call myself a self-taught experts. But I put a lot of time into this stuff, and until someone says that, you're wrong here, and if they can prove it, well, I'll backtrack. I'm not stupid. I'm not obstinate. I mean, if someone shows me and proves to me I'm wrong, that's different than just saying I'm wrong. Anyway, point number 132. Why didn't the government follow the statutory precedent from the old age security with retirement income security benefit in 2015? Now, I'm trying to figure out, because, again, I might have wrote that months ago. But I'm pretty sure I'm thinking about back in 1987, I believe, the federal government, the conservative government, decided to limit old age security to rich people couldn't get it. And they decided to set the rate for clawback at $78,000, and it goes up to $128,000. So at $78,000, you start to claw back a bit. At $128,000, you don't get a goddamn dime of old age security. Now, first of all, I'd like to register an objection to that, because the old age security is supposed to be a pillar of our fucking retirement. So they shouldn't care about how much money you got, how much money you have in the bank, how much money you have coming in. They shouldn't fucking care. It should be like it was a universal program, because it's part of the government policy for pensions. That's it. They should never have changed it. But they wanted to save money. More and more people were getting old and retiring. So they wanted to save money, so they decided to put in a clawback for people who made too much money. And that's an easy sell to the taxpayer. Right? It's just like saying that people are having money stashed offshore. Like, you can sell things like that to the taxpayer about going after tax evaders, and you can sell the idea that, we're having a lot of money getting spent on people that don't need it. So we're going to introduce a clawback. Now, my point is, in 2015, they decided to, well, actually, I just realized I'm on a different topic altogether, but related, okay? Okay. In 2015, the government brought in the retirement income security benefit. But they started to claw back things, and the old age people, they claw back, and VAC claws back the old age. Now, back when, just before COVID in 2019, this was when I decided to get out of a little bit of a lull I was having, and I wasn't doing much on the Veterans Affairs front, at least with the Ombudsman, and I called up or submitted a request to have them investigate the fact that the Old Age Security Act, Section 36, states that no one can claw back the old age security. So therefore, Veterans Affairs Canada might have put it into the regulations, the Veterans Wellbeing Act regulations, Section 22, but they ought to have done their homework first, and they should have consulted the existing laws that were in effect that says they couldn't fucking do it. So that was why I called the Ombudsman to ask them to investigate. It's common sense. You can't have one law disobeying another law. So the point I meant about the salary, well, the wage income for the old age security, that's an entirely separate issue. The issue I was meaning to get back on track with what I wrote down, now that I jog my memory, is the fact that it's like Amanda Madiang. I think corporal retired Amanda Madiang had this problem when the employment insurance she was getting wanted to take the earnings loss benefit, income replacement benefit into account, but the Veterans Affairs wanted to take the employment insurance into account. So both government payments wanted to take each other into account. Now that's the exact same thing that might happen with the age 65 problem. So when they brought in the retirement income security benefit back in 2015, what happened was they got rid of the lifetime payment in 2006. Okay? Everybody knows that, I believe. So they got rid of the pension. New pensions were not awarded after 2006. So they decided to get rid of the lifetime payment, and they decided to end payments at age 65 with the earnings loss benefit. Now, many people complained about the fact that you still got to live after age 65. How come you're cutting us off? So instead of doing like the Canadian Veterans Advocacy, Mike Blay, I saw a report where they said, why don't you just extend the earnings loss benefit till you die? That was a perfectly good suggestion. But you see, that didn't save them any money because they were trying to get rid of the lifetime payment. They didn't want to have a lifetime payment at all. So they brought in the retirement income security benefit, which was 75%, I believe, 70% of whatever the earnings loss benefit was at age 65. They brought that in. Now 70% of 70 is 49. 70% of the other one is, you get a fraction of the 75% instead of all of the 75% had they kept it going. Now, of course, in 2016, then they increased the amount to 90%, so it became 70% of 90%, which is 63%. But they're still saving, 17% by making it a percentage of, instead of making it just continue. It would have been a lot simpler had they just left it carrying on. Because no matter what, it's not income, first of all, it's compensation for injury. So people get caught up on the percentages a lot, right? Like my cousin said to me, Jesus, Matt, you can't get more than what you made when you're working. The thing is that people advance in their careers over time. So in the Andrews versus Grand Toy, Supreme Court of Canada, 1978 case, they had a fellow who was made a quadriplegic or a paraplegic in a car accident. When they were assigning damages, they didn't look at what he was making, $800 a month, and assign damages. They said everybody gets promoted and other stuff over the career, gets more money as you get older. So therefore, we'll use $1,200 a month to quantify the damages. So it's not income replacement we're talking about. We're talking about basically damages for your injury. So you have to take into account your potential career, your seniority and promotion, which was, by the way, the intent behind the permanent impairment allowance, which became the career impact allowance, which became the additional pain and suffering compensation. So it was originally stated in 2006 that this payment would be to satisfy, to compensate, to recognize the lost promotions and career that you would have because of your injury in Canada's military service. But they made a mistake in making it an economic payment, first of all, because all compensation for injury is non-economic because it's your body, it's your capital, it's what you can rent to somebody in order to make a living. So if you hurt your capital, you have to get a payment that is capital, not income replacement. It's a capital payment to replace a capital loss. And that's from Andrews versus Grand Toy as well. So anyway, the government's always trying to cut back and save, and they were looking at ways to save, and well, the age 65 thing was an easy way to save. And if anybody questioned on it, they'd say, well, we're just doing exactly what workers' compensation and other agencies are doing. But the thing is that when they do that, they are causing the person who was injured to lose, and they save at our expense. That's pretty nasty when you think about it. It's the definition of, conflict of interest. Because they want to save, and it's not to save and everybody benefits, it's they save, but somebody else suffers. Okay, point number 133, pension buybacks and bridging bullshit. I paid for my buyback when I was also, which also has to do with bridging, include bridging, and I pay for bridging overpayment, which is absurd. Okay, here's what I'm talking about. When I bought back my reserve force pension plan, it wasn't there all the time. It was brought in 2007. So I served from 99 to 2007. I had 8 years I could buy back, or I could not buy it back. I could make an election. I elected to buy it back. When I bought it back, it gave me a higher pension, which should say, well, you get what you paid for. But because I eventually got my service income support insurance plan, well, I didn't get as much SISIP because they clawed back my reserve force pension plan. Now, when I made the buyback, it obviously would have been higher because of this bridging thing that they call, which is bullshit. But Section 15.2b of the Canadian Forces Superannuation Act has a clawback for if you get the Canada Pension Plan. Now, they call this bridging, and it's supposed to be to bridge you from the period in which you retire, but you can't get your normal pension. That's the bullshit they try, the snake oil that they try to tell us. They try to say that this is for the period between, say, 55 and 60. Because after age 60, you can retire and get your Canada Pension Plan, and there is no deduction from the public service, the RCMP, or the Canadian Forces Superannuation Act pension. Okay? So it's only for a short period that this bridging is alleged to exist. Now, as a side note for that, the public thinks that this is a perk. Public servants, military members, and the RCMP members, we think it's a penalty, but the public thinks it's a perk. Because they say private companies don't have this bridging, so how come the government is wasting our tax dollars? So this is the crap that I'm trying to help get fixed one of these days. Because if you have two pensions, you're required by law to pay into the Canada Pension Plan. The Canada Pension Plan Act states that you have to, and therefore you do. You're required by law to pay into the Canadian Forces Superannuation Act pension. Now, two pensions, two acts, and two different contribution rates, different vesting rules, different pension plans, everything is different. The Canadian Forces Superannuation Act, the RCMP, and the Public Service Superannuation Act pensions are essentially a private pension plan, just like a normal private employer has, and it's when you save your money until you retire. So you put away money when you're working, serving, and then you take it out when you retire. So it's property. It's not income. It's money in the bank. Now, how do I know that and say that with a straight face when everybody says that it's income? Well, it happened to go to the Supreme Court of Canada in 1990 on a Canadian Forces veteran, Clark versus Clark, Supreme Court of Canada, 1990. So the Nova Scotia Court of Appeal said that the Canadian Forces Superannuation Act pension is income. Now, they had a choice. It had to be either income or property. That was the two choices that the Nova Scotia Court of Appeal had. They decided it was income. Now, I could speculate about what the differences are between income and property and what the ramifications were, and it was a divorce case and all that. But basically, it was a flip of the coin, and they chose it was that. Now, one side or the other side decided to appeal it to the Supreme Court of Canada. And the Supreme Court of Canada said, thank you for your opinion there, Nova Scotia Court of Appeal, but you're wrong. Pensions are not income. They are property. Now, that is the final word for pensions. Okay? And especially the pension that was in question in court. The Canadian Forces Superannuation Act pension is property. And anybody says it's income can go fuck themselves, because the Supreme Court of Canada already pronounced on it. See? Now, here's a couple of implications for that. The Service Income Support Insurance Plan in Section 24A and 44A of the policy, they want to claw back the income that you get from your pension. But shouldn't they know that pensions are legally property and not income? And that very word, income, came up in the Manouche case. And the judge in the Manouche case was saying that, they could have defined income in the policy and said it was this or said it was that and whatever, which I say is a red herring. Income is not even defined in the fucking Income Tax Act. So everybody is supposed to know what income is. It is not defined somewhere, because if they clearly define it, someone would try to find loopholes. What income is an increase in your wealth. Okay? So if you had no money before, but you got a job, and you gave some time to your employer, and your employer then pays you. Well, you had an increase in your wealth because you got paid, and that's income. Now, in the Manouche case, they brought up a case that was really obscure, I guess is the word I'm looking for. Stitzinger, Ontario Court of Appeal, or Ontario Superior Court, some year, I can't remember. And they talked about the difference between income and property. And they were talking about, like, income is the fruit of the tree, but the tree is your property. So, you know, it's like my analogy about you being a robot. See? So basically, you know, anyway, my point about all this is that both the SISIP policy and the Veterans Affairs earnings loss benefit / income replacement benefit, their reason to claw back your Canadian Forces pension, your Canada pension plan, or anything else is that you received income. But they're wrong legally because you received your property back. See? You got your property back that they held in trust for you. Now, they ought not to hold it in trust for you, really, at least in my opinion. They should have an independent trustee look after people's pensions, because that's how everybody else does it. Nobody would agree to have the employer look after their pension when the employer and employee have exactly opposite interests. The employer wants you to work for nothing, and you want to get as much as you can. You want everything without doing anything. So even though work is mutually beneficial, you work, the company, the entity makes, you know, a profit, is successful, but you give up your time and they pay you, and you're supposed to both benefit. But with the government having these pensions and with them administering the pension, then they have a huge conflict of interest, what I would call the fatal conflict of interest. So one more point, and actually I'll bring it up in the next one. I'll link them. The last point I'll mention tonight is the pension promise. Now, this seemed really familiar, so I think I might have done something on this before. But basically, the pension promise, if I may be so bold as to ad-lib it, you promise to work for somebody, and they promise to pay you something now and something in a pension. Okay? So the details can be worked out, but it's by agreement, it's mutual promises. Now, the thing is, though, the government, not just the government, but in the old days, everybody thought that the employer gave people pensions out of the goodness of its heart. That it wasn't a quid pro quo. It was sort of benevolent. Now, the more modern interpretation is, and the more accurate, legally correct one, is that you get something for something. Quid, that's what quid pro quo means. So, for example, I'll give you two cases that I know of. I'm always quoting. Cunningham versus Wheeler, 1994, Supreme Court of Canada. And the case was about people injured in an automobile accident, and they had long-term disability in which the employer paid some of the premium, just like SISIP. So they were trying to say in the case, was this amount of money received in the long-term disability income or insurance? Now, when you think about it, it's a dumb fucking question. You paid your premiums, you got your insurance. You didn't get income. You didn't have to serve somebody for to get it. You got it in relation to the insurance contract. Now, in the common law, however, income can be deducted from damages. But insurance is exempt from clawback, see? Because it's non-indemnity, which means it doesn't compensate for anything, and it's contributory, meaning you bought it. Now, the argument was, they tried to say that the person didn't pay all the premium, therefore, they didn't pay for it, therefore, we should be able to take it into account. The judge looked at a lady by the name of Ms. Clark, I think. Anyway, Ms. Clark paid 30% of this premium, and the employer paid 70% of the premium. Whatever they paid they paid to her on her behalf that she earned, and therefore it is her payment. Now, that has important tax implications for us, because the 85% that the government allegedly pays, they don't really pay because the Canadian Forces member earned it. Now, if you pay 100% of your premium, you're supposed to get long-term disability that is tax-free. That's the rule, okay? So Income Tax Act Section 61F requires the employer to make a payment into the insurance premium, or you're supposed to get a payment without any taxes. So that's one important implication. Now, the other case I was talking about is about pension. Now, pensions and insurance are very closely related. There was a case in 1969, I can't remember the name of it, but it was an English case, and they were looking at the amount of money a person was getting in a disability pension, and they decided it couldn't be deducted from a damages payment because it was much akin to insurance. So they said, why should the person who was injured be worse off than if they were getting insurance, because they're getting a weekly pension? Like, they paid for this with their weekly contributions to the pension. Now, fast forward to 2013, and we have a Supreme Court of Canada case about IBM versus Waterman. Same thing. IBM tried to say we paid all of the premiums, all the contributions of the pension. So therefore, even though we fired this man unjustly, we ought to be able to take into account the payment we made, because he's getting a pension now, and we ought to be able to deduct that from our damages. Now, my first idea in this is they should go fuck themselves, because they could have left him working until he retired and not fired him unjustly, and thus incurred damages for unjust dismissal. They could have left him alone, but they didn't. So then they tried to pull a fast one and reduce the cost of their damages. Their argument was, is we paid all, he paid none, therefore we should be able to reduce our payments to him in damages. The judges said the exact same thing that I told you about the murder case, and they said, look, even though Mr. Waterman didn't pay a cent in money, his time has value, and therefore he made the payment even though you physically made it. Now, that's the exact same thing as the SISIP program and the Canadian Forces Superannuation Act pension. Even though the government fulfills what's called its actuarial responsibility to keep the plan afloat, it has to put in enough money to keep it alive. So it can't let it die. So when the experts, the actuaries, tell the government you had to put in this many $1 billion or hundreds of million or whatever it is, see, the government thinks it's putting in its own pay, its own money. But what it is it's a payment that's owed to the person because they served in the past, because pensions are property. So they need to get their head around this, and that was 9 years ago now, 2013, this is 2022. So the government should know about the fact that any payment that it makes into the Canadian Forces, Public Service, or the RCMP Superannuation Act funds, it isn't making a payment out of the taxpayers' money. It's simply doing what it's supposed to do in any pension plan. But the government wants to look good. Okay, they often want to say, look at what a generous pension plan we have. Okay, how is it a generous pension if they give you the money that you put into the bank and they held on to it, and then when you're retired, they give it to you? Tell me how that's generous. That doesn't fit the definition of generous to me. I was so incensed when I saw that in a Hansard report. And this man that said it was a member of Parliament from Edmonton, and he used to be in the military and the Air Force. Laurie Hahn, I think his name was. I called his office up, and I didn't know that he lost his seat. And I ended up talking to the Liberals instead of the Conservatives up in Edmonton. And they said, he's not here anymore. Well, I said, here, I'll tell you why I was calling. I was going to give him a piece of my mind, because he went on the record in the Hansard And he was saying that Canada gives all these Canadian Forces members a generous pension. And I was going to say, if they give you the money back after they took it off your check and you earned it, and they give it back to you when you retire, how can that be considered generous? But they have a way of twisting things. They want everybody to think that they're the best thing since sliced bread. They don't want to admit that pensions are not given out gratuitously anymore. They don't want to understand that pensions are property, because that would throw all of their plans to screw us over, right? Because when pensions are property, you should get your Canada Pension Plan property, you should get your Canadian Forces property, and neither should reduce the other, because they're both your property. How can they rationalize reducing one for the other? Last point, saying I'm waxing on more than I meant to. I'll refer to prove my point, to 100% accuracy. Now that shouldn't be possible with politics and stuff and laws. But in 1964, in February of 1964, and Mr. Anyway, this guy was asking the Minister of Veterans Affairs, Judy LaMarche. He said, listen, what happens in 2 years' time when we bring the Canada Pension Plan in? What happens if we have a civil servant who's going to get a disability civil service pension and he's going to get a disability Canada Pension Plan? Will he be allowed to keep both? Yes, of course, she said. If he has 5 or 6 pensions, he'll get them all. Now that's the way pensions are supposed to work, because you own them, because they're your property. If you retire, they can't reduce one because of another. One of them has nothing to do with anything. Like, you know, I mean, there's different reasons for you get it. Now, I said I'd shut up, but one other point came out. See, the government, even though Buddy had his answer and was shut down by the minister, they still worked against that idea of giving both at the same time. And I can give you a reference to a 1974 RCMP Superannuation Act actuarial report. And they said that only 10% of the people who get medically discharged from the RCMP qualify for the Canada Pension Plan Disability because of the strict definition under the Canada Pension Plan Act. Now, that was their way of avoiding paying both. You would get your RCMP or civil service or Canadian Forces Superannuation Act pension, but the Canada Pension Plan Act, they used a very strict definition to say you couldn't get that one. So Mr. Chatham, or where the fuck his name was, they got their way. The executive branch of the government avoided paying both at the same time. Now, somewhere along the way, they brought in the bridging formulas. It's in section 10, I believe, or maybe 12.2 of the Public Service Superannuation Act. It's in section 15.2b of the Canadian Forces and the RCMP Superannuation Acts. So somewhere along the way, they decided to put this clawback in all of the federal pensions. But they don't have a corresponding section in the Canada Pension Plan Act to reflect that they could do this, because they're different acts. They're different pensions. The Canada Pension Plan one is supposed to be a quasi-constitutional one that you need 7 out of 10 provinces to make any changes to. That's because pensions are supposed to be long-term. You're not supposed to make changes all the time. You're supposed to be able to look at them, plan ahead, and count on them. And that's not what they're doing. And they're screwing over mostly. I mean, there are healthy people that should get 2 pensions at age 65. But I'm trying to fix it for the disabled person, because the disabled person gets a reduced Canadian Forces or Public Service or RCMP pension. They then get a reduced Canada Pension Plan, and the reduced Canada Pension Plan further reduces the other Superannuation Act pension payment. It's crazy. Listen, thanks for watching, and I'll be back next week with another installment.